We'll now hear from Mr. Fernandes. Mr. Fernandes, you have 5 minutes, sir, and you may begin.
Thank you. I would like to thank the chairman, ranking member, and other members of the subcommittee for the privilege of offering some thoughts as you consider congressional oversight and the enforcement of subpoenas. Congressional investigatory power is deeply rooted in our political system and is embedded in our Constitution, which grants Congress the right to legislate. But there's a problem. Over the last 4 decades, there has been a congressional oversight effectiveness crisis, particularly with respect to oversight of the executive branch. Executive branch officials have refused to comply with subpoenas, and resolution of these disputes in the courts has taken too long. An example proves instructive. In early 2019, the House Oversight Committee subpoenaed Mazars USA for documents related to the President Trump's and his business's finances. In the ensuing litigation, the House won at the district court and circuit court levels. In July 2020, the Supreme Court held, in accordance with precedent and centuries of history, that Congress has broad investigatory powers and can investigate the executive branch and indeed even the president himself. However, because the court concluded that the lower courts had not properly taken into account separation of powers concerns, the court also vacated the lower court's opinion and remanded the case. And now, more than 2 years after the start of the lawsuit, the issue is nowhere near resolved, and there's still a pending motion for summary judgment at the district court level. This is just one example, which I'm providing simply because of its ongoing nature and because it was litigated at every level of the federal court system. How one feels about any given example might be influenced by one's partisan affiliation, one's feelings about a presidency, or one's commitment to the underlying subject matter. But the problem is larger than any subject, political party, or presidency. In countless cases, delays in the courts have prevented Congress from receiving the information to which it's entitled and which it needs to do its job. The consequences of such delays are particularly acute in the House, which is not a continuing body. Each time a new House is sworn in, its ongoing investigations end and its subpoenas expire. If new leadership decides not to reissue subpoenas, the ongoing litigation could be mooted, foreclosing the chance of the House receiving the information. One possible solution is for Congress to establish a pathway for expedited court review of oversight disputes. Congress has considered this option before. For instance, Congresswoman Dean in the last Congress and Ranking Member Issa in the 115th Congress introduced legislation that would streamline the process of resolving disputes over subpoenas. According to both legislative proposals, anytime the House, Senate, or one of its committees or subcommittees brings a civil action against the recipient of a congressional subpoena, the federal courts at every level must expedite disposition to the greatest possible extent. Both pieces of legislation further provide that if requested by the plaintiff, the action shall be heard by a 3-judge court and shall be reviewable by appeal directly to the Supreme Court. The bills also require notice of appeal to be filed within 10 days. Allowing for expedited review and a direct appeal to the Supreme Court would allow for a quicker and more efficient process when it comes to enforcing congressional subpoenas. This streamlined review has precedent. For example, 28 U.S.C. Section 2284 allows for a 3-judge panel for actions challenging the constitutionality of apportionment of congressional districts or apportionment of any statewide legislative body. In addition to making provision for a 3-judge panel and streamlined appellate review, Congress should consider clarifying that this pathway would govern regardless of any other statutory schemes implicated by the subpoena. To cite just one example, documents created or maintained by the White House are subject to the Presidential Records Act, which sets out its own procedures for resolving disputes. Congress should make clear that other statutory schemes notwithstanding, disputes over congressional oversight in the federal courts will be resolved through the expedited pathway. In conclusion, Congress's right to obtain information is not in doubt. What is in doubt, however, is whether Congress will be able to obtain the information to which it is entitled in a timely fashion. Currently, when oversight disputes go to the federal courts, this remains an open question. Congress should consider expedited court review as one way of answering it. Thank you.